Hi, everyone. Harry here to talk about prosecutorial misconduct. Not really. Prosecutorial misconduct, according to Donald Trump and his lawyers, and his overall strategy for combating the killer indictment of 37 counts in federal court. And this is it in a nutshell. He can't win this case. He can only, at the very best that could happen is if he draws a couple ardent MAGAites who just don't pay attention to the law, he could get a hung jury. So he's a goner, but he's got one escape hatch made much wider by the very unfortunate, apparently random selection of Judge Eileen Cannon. And that is to delay things long enough so that the trial itself hasn't happened when people go to the polls in November 2024. And he's the nominee, or even if DeSantis is the nominee, if either of them wins, they could then just scuttle the prosecution. So that's his hope. And moreover, he doesn't want the trial to go forward because he would have the brand of a felon, and a really serious one at that, under the espionage and other very serious federal statutes. So he wants to try to delay things. In the normal course of events down in Southern District of Florida, which moves rather quickly, and with there being no venue issue, you could imagine that there would be, the trial ought to take place around next summer. But Cannon is a really frightening draw here, and some combination of her lack of innate talent one way, or when her performance was so spectacularly terrible with Trump before, and it combined really obtuseness and apparent bias. So all she has to do is indulge him, and he'll, be pushing on her to do it, or his lawyers will, in motions that delay things to push things past November, and that's his best chance. That's his sort of one chance, it seems to me, and he is completely focused on it. All right, so when they went, his lawyers, to make their last-ditch appeal to the Department of Justice, by all accounts, their argument was there's been a lot of prosecutorial misconduct here, and therefore you shouldn't bring the case. A really stupid waste of a meeting, something that would fall for, among other reasons, it's just not a good argument for not bringing a case of such serious magnitude. He didn't give a legal argument or a practical argument about why it's hard for them. They just complained about prosecutorial misconduct. But you can expect the same thing to happen on TV yesterday. His former lawyer, Parlatore, went on and said, there's so much prosecutorial misconduct, and that's where we're going to make a big stink about. And when pushed, it was actually on live TV, I think by Andrew Weissman. Basically, they got very little. The one concrete allegation is that, so there's just a scattershot, oh, they did this and that and the other thing wrong. The one concrete thing seems to be that Jay Bratt, who's a lead lawyer in the case, he was the one who showed up in court at the arraignment, when they questioned Walt Nalta. Nalta's lawyer has put his name in for a judgeship, and Pratt mentioned this fact in passing. Now, they've tried to spin this up as some suggestion that Pratt for the Department of Justice was basically saying, you better, go easy or make Nalta plead or whatever, or you're not going to get your judgeship. It is ludicrous. I worked on judicial selection at the Department of Justice. It's got nothing to do with, it's a political function of the president. It's got nothing to do with the career folks in the criminal division or anywhere else, as Bratt is. And they would have no role at all. And moreover, Bratt would have would be silly and wildly improper besides. He's way too smart for that, to be saying something like, you better play ball or you're not going to get your judgeship. It's really ludicrous. But there's a more important defect with it, which is the Supreme Court and the 11th Circuit have made it very clear. You can imagine so many defendants believe sincerely, maybe some accurately, that when they've been indicted, there's been terrible prosecutorial misconduct. And they frequently bring these motions to dismiss charges based on it. And the Supreme Court's very clear. You can't do it except in the most narrow and extreme circumstances. Maybe if you've been had your rights abridged, you can have other remedies. But the dismissal of an indictment and charges that a grand jury has brought, that besides that has a real public cost, it's also, the grand jury has now solemnized these charges. They're the sort of acting entity, and there's no, unless, and this is the very narrative, unless you can show with really strong evidence that the grand jury itself was hugely prejudiced in its deliberations, it doesn't matter. And we're talking about much, much more serious prosecutorial violations than anything Trump has charged, like Brady violations, and you didn't turn over this, or you didn't present things to the grand jury, and a lot of things. But if the grand jury made its own decision based on competent evidence before it, bring it up at the trial or bring it up in a separate action, you cannot dismiss the indictment based on it. So this should be something that any judge would make quick work of and just say, unless you come in right now with some affidavits that make this case, forget about it. What's your next motion? But Eileen Cannon is not any judge. And you're going to have the Trump lawyers come forward and say, oh, judge, this is so serious, and we want to depose Jay Bratt. And we, which the Department of Justice would say, you can't do that. Or we want to talk to grand jurors, or we want to write real briefs on this, or we want to argue why our facts, which they haven't even established, meet the narrow channel. And that means evidentiary hearings. That means motions. That means time, like 2, 3, 4 months. So if she gives them any running room, boom, we're in a optimistic scenario with any other judge, let's say this case would go forward around June. So that gives them, they need 6 months or so for her to gum up the works, indulge meritless claims to get it over the hump of November or maybe even January. So it looks to me like 2 or 3 months could go by right there. So, and we know they're going to make a big stink about it. And by the way, as long as it's pending, that's grist for the mill for Trump on the campaign trail. As the judge said in court, or as we've told our lawyers, and he can scream prosecutorial misconduct. It's garbage on the facts. They don't have the evidence. But even more importantly, it's a non-starter under the law. And yet I think she could well let it start. Not end. I think the law is so clear that even she would be, I would not expect her to actually approve the claim at the end of the day. But here, the escape hatch that has widened for Trump starts with delay, and this is a very possible big chunk of it. And we'll see, but the indications are this is where they'll come out of the box. That is after perhaps saying, oh, we just got appointed judge. Now they didn't even have a lawyer yet, so he'll be arraigned later. We need time to get up to speed. How's 3 months? And that's something that Cannon can grant very easily, things like this, and be essentially not reversible, and wind up giving Trump the kind of delay that he still would have to combine it with an electoral victory or one for DeSantis, but actually defines a kind of escape hatch that would be a travesty. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.